back though and got the rest of them.
Look and see if you find it. Good afternoon. This is Judge Alyssa Perez resuming the criminal docket for the 210th District Court for October 31st, 2023. We are back on the record in cause number 2022-0D00012, State of Texas versus Crystal Lynn Guillen. Mr. Montoya.
Thank you, Judge. Judge, I apologize to the court. I did fail my client this afternoon because I left out crucial information that I should have brought to the attention of the court. And that is that she is a Emergence Health Network consumer. She is under the care of a Dr. Baeza, capital B-A-E-Z-A, at EHN, and she is compliant with the medication regimen that he has prescribed. I didn't mention that before. I apologize. I should have mentioned that. Her next appointment is on November the 8th at 4:15 p.m. In order to continue care under Dr. Baeza at EHN. And I think it would have behooved me to have mentioned that Ms. Guillen, apparently there was an email from the department to her that she missed seeing at first because she was incarcerated on that little misdemeanor. And then when she got out of jail and made contact with her supervision officer, she found that email, and I guess there were some reporting instructions in there that she had missed. But she did make contact on July 2nd with her supervision officer. And then again in August, I don't have the exact date, but apparently she was instructed to report on August 28th. But on that same date, she had a hearing in the misdemeanor case. So she was stuck in a quandary there. But all that is by way of information, Judge. As to the court's ruling, of course, we respect the court's ruling on my motion, but I would like to follow up with an additional motion, and that is a motion for a bond. I believe my client's on deferred adjudication, so I believe she qualifies for a bond, a reasonable bond. I want to tell the court that as to the misdemeanor, I represented her on a court-appointed basis. She's indigent, Judge. In this case, I'm representing her on an agreement to represent her. I believe that our payment plan is $60 a week because that's all that she can afford along with her family. Her family's helping her, Judge. And she recently was hired to work at Gainful Employment. She's going to be starting a job, Judge.
She's what? I'm sorry, it cut off.
And
I didn't hear you, Mr. Montoya. She start what? Cut off.
She's going to be starting a job. I'm sorry. A call came in right in the middle of my statement, but I rejected it. It's she's going to be working at a job. She's going to be with Gainful Employment, continuing with her treatment and continuing with compliance with probation. So I would ask the court to set a PR bond, and then I'll walk her through the fast track process with the court's permission.
Mr. Vandenberg, you're on this one?
I am on this one, Your Honor.
Are you prepared to go forward with the request for a bond?
No, Your Honor. You had at least 3 days notice. We'd appreciate it.
I'm still not quite understanding, Mr. Montoya, with that additional information. From what I understand, I haven't gone in to look in the jailing myself, but I understand she was in custody June 12th, 13th, and 14th, thereabouts, on that criminal mischief that got dismissed. But she wasn't. When were the instructions sent to her, Mr. Escobedo, regarding her reporting at the end of June, right? It was June 20-something, 22nd, something like that.
Yes, Your Honor. I could definitely go ahead and obtain that information.
And actually, Judge, I have not obtained a copy of the bench warrant. I'm not making a complaint. I'm just stating factually. It just occurred to me, I'm not aware of the reason for the issuance of the bench warrant.
It was the criminal
It
mischief.
was due to the
The
rearrest.
new arrest, okay.
Let me look it up. Warrant.
If I may say, Judge, the other part of it that I'm hearing is that neither the department nor the DA's office is indicating that they are moving for revocation in this case, but rather for more strict reporting instructions.
Mm-hmm.
Well, Your Honor, since the other matter was dismissed, that's the basis of this. Probably won't move forward on a revocation.
So, okay, you won't move forward on a revocation. You're not ready for the bond, but I think ultimately, and I get it because he's just asking for it now. But I'm always trying to look at things big picture. I feel like she did not, I don't know what the basis is on the dismissal. I haven't looked. I haven't seen anything with regard to that criminal mischief. But what are red flags to me is that she's having this, not so workable relationship with probation. I understand maybe there's a mental health concern and there may be stressors with having picked up the new case, but she didn't report for June, July, August, September, 4 months. And I'm not real happy with the behavior with the probation officer. So if what ultimately we're saying is, but then on the other side, let me put this, on the other hand, I'm not real happy that probation did not get her screened. I'm glad to hear that she is receiving services on her own. Is that at the very least, if we're looking at big picture, what I'm thinking is she's going to give me a jail commitment and she can do it work release, but there's going to be a jail commitment because I have a feeling there is a lack of understanding on Ms. Guillen's part about what it takes to follow rules. Like she kind of was over here, dealing with, the new case and kind of stayed out of our way while this bench warrant was out there. And now she's coming in and everybody's just like, well, let's just put her back on under, although I understand probation saying having her report more than once a month. I'm not sure that's the right way to go. But I do think there needs to be a sanction for some non-compliance. So
That's fair, Judge. That's absolutely fair.
So if we're really, kind of taking the short way to what the ultimate resolution is going to be, in terms of reporting, Mr. Escobedo, prior to June through September, had we had any issues with her reporting or compliance overall?
Not at all, Judge. She was reporting each and every single month. I believe we also have some community service. Let me see. So there weren't any violations, Judge. She was reporting as instructed.
Okay.
And she was also making her payments as well. So there weren't any red flags, Your Honor, as far as her compliance is concerned. It was after the rearrest that we started incurring some issues.
Mr. Vandenberg, was there anything, I've never looked at that criminal mischief. I mean, was there anything that brings you concern about either that offense or anything with regard to the defendant's conduct? I mean, you all dismissed it. So for my purposes, it's pretty much like it never even happened.
Yeah, sure. If I may, it seems like she had a manic episode and she acted out. And if there is strict monitoring over her medication level, that might even everything out, Your Honor. Because according to Mr. Escobedo, she had no problems whatsoever. And then all of a sudden, total non-compliance for a few months. Now she seems to be back on the wagon. It may just be a need for strict supervision, especially with medications.
Mr. Montoya, this is where I'm ready to go from here. A 4-day jail commitment, she can do it work release. To the extent we still need to go down the mental health screen, I'm satisfied that we modify her to maintain all of her EHN mental health treatment as a condition of her probation, but I don't want that to be exclusive. In other words, I want probation to have its own benchmark of what her needs are in the event, you know, for whatever reason, she is no longer able to receive services on her own, that probation take up the slack there. So if that means, Mr. Escobedo, that we still get her screened, I don't know if I wrote down Takumi or if it was just a mental health screen. I think we need to get a handle on that. I'm willing to allow her to rely on the treatment she's already receiving as long as that is working.
Yes, sir.
So we can do that. Under those conditions, I don't need her to report more often. What I just need her to do is to report and not commit new offenses. And then every other condition is the same unless I'm hearing something else was a factor here.
No, Your Honor, I think, you know, if I remember correctly during one of our conversations, I do believe Ms. Guillen's medication has been adjusted, which is a frequent occurrence in mental health care. And she's doing great as far as when she complies, when she takes it, she does very well. Like I said, she's going to be starting a job pretty soon.
All right. So in that sense, then your request to withdraw the warrant is granted, the basis being the modification and the sanction, the jail sanction. Those will be, those are to be completed within, I would say, before the end of the year, Mr. Montoya. And like I said, she can do it work release, weekends, however she wants to do it. Okay.
Very good. 4 days of probation.
Well,
Very good, Your Honor.
Okay.
Your Honor, if I may.
Yes, sir.
Yes, Your Honor. May I have Ms. Guillen give me a call, Judge, just so I can go ahead and provide her with a report date for the month of November?
Yes, absolutely. Ms. Guillen, get in touch with your probation officer. Okay.
Yes, ma'am.
All righty.
Do
Anything
you
else?
have the number, Ms. Guillen? Ms. Guillen, do you
I
have
can
the
go ahead and
number?
provide that to you as well, Mr. Montoya.
Okay, thank you, sir.
Sure.
I appreciate it. Thank you very much.
All right.
Your Honor, may we be excused?
You may have a good day. Thank you.
Thank you very
Thank you,
much.
Judge.
Who's next?
Thank you. God bless y'all.
I have Mr. Huffman back with his client, Judge.
Is that Mr. Estrada?
Yes, Judge.
Okay, Mr. Huff.
Yes, thank you, Your Honor. I
Hold
did-
on, hold on.
Oh,
Let
I'm
me
sorry.
call it back on the record. Okay. All right. Miss Deverly, ready? Back on the record in cause number 2021-0D01176, State of Texas versus Luis Manuel Estrada. May I have announcements, please?
David Vandenberg on behalf of the state is ready.
Rick Huffman on behalf of Mr. Estrada, we're ready.
Okay,
Maribel Gonzalez for adult probation.
and we are, and is Mr. Estrada, okay, Mr. Estrada is there. All right, and Mr. Huffman, you had needed a minute to speak with your client.
That's correct, Judge. And Your Honor, my client did have a few slip ups, but I think he's
Well, that's
got
what I told you before we took a break.
right. And I think the reason being is he's been overwhelmed. He's been working 40 hours a week at Olive Garden. His mother, who he lives with, had a stroke recently. He's been changed probation officers. He thinks he knows the name of his probation officer now, but it's been kind of confusing. He did get a calendar, Judge, so he's got the tap classes. He says he goes once a week to tap, and then I think he's scheduled for a probation report date on the 15th. He kind of just got this new calendar on the wall, and he's got all of his appointments there. So I think he's on track, Judge, and I think he's talked to the probation department. I think they've gotten to some understanding. So I think I want to tell the court that I think we got this under control. Hopefully.
All right, Ms. Gonzalez.
Okay, Your Honor. As you know, Mr. Estrada was released from custody after he finished his 30-day commitment. He started attending TAP. He has missed one individual and a group because of work, and for TAP he was late for the group because he thought it was at 11 and it was actually at 10. He has been modified to the substance abuse caseload. He's going to begin reporting to Ms. Lujan. Your Honor, I would like to also let the court know that when he does come in, because he's been reporting to me, I do ask him if he understands, if he has any questions, and he always says he is. I instructed Mr. Estrada to report for a drug test on the 26th. He failed to report, and he told me that he couldn't go because his mother had a stroke on that day. Other than that, I mean, he is reporting when instructed. I did encourage him to get a calendar because he says sometimes he forgets, so I told him to put an alarm. But other than that, oh, and another thing, Your Honor, he was receiving mental health services while in custody. I asked him about it, and he says he doesn't feel that he needs them anymore. That he thought it was just because he was in jail.
Was he supposed to be screened for mental health services? Was that part of
So,
his?
Your Honor, it was just for the substance abuse, and like I said, he has been modified. I've already given him instructions to report to Ms. Lujan on November 15th, and he's still attending TAP.
Has there ever been, well, let me look. In the meantime, I'll hear from Mr. Vandenberg if this is yours.
It's mine. I think the facts have been well stated, Your Honor. My concern is that he failed to report for 3 months out of 4. He did report in May, but not in March, April, and June, it appears. And he had a positive UA at the beginning of May 4th. So he's not really complying, certainly completely, with his probation. It seems that he's on the right track. I think there should probably be some kind of time penalty for this.
I think there was already, Judge. The
He did
30
a
days.
30-day jail commitment.
Yes.
Yeah, I'm not real psyched. I'm not real psyched about there not being a sanction here, Mr. Huffman, and we were already at 30 days, so.
Yeah, and I think a good admonishment would do the trick, Judge. He's got the scheduled court TAP classes. He's got the report dates. I am, obviously the drug test. I don't. Did he ever go take a drug test?
He hasn't yet. That's not as of today.
I mean, I think maybe he needs to take that drug test today, or something. But then but I think he's doing okay, Judge. Other than that, I mean,
So he has until end of day tomorrow to complete his drug test, Ms. Gonzalez.
Yes, Your
Please
Honor.
provide me the results via email. We'll be in trial, so via email on Thursday.
Yes, Your Honor.
I'll just say this, if he tests positive, get me a bench warrant.
Yes, Your Honor.
If he doesn't, then we'll set him for not, let's see, what are we, 31st? We'll set him for the 14th. I'm looking at a time commitment. Okay.
Yes,
So,
Your Honor.
okay. Mr. Huffman, you understand? So your client understands? He has to test and by the end of day tomorrow, and then they'll send me the results and we'll find out if there's a bench warrant or not. Okay.
I understand. Mr. Estrada, did you hear that, Mr. Estrada?
I see him nodding yes. All right.
Okay.
Thank you, Ms. Gonzalez. Thank you for your input.
Thank you. May I be excused, Your Honor?
You may have a good day. Who's next?
Thank you.
Bottom of page 20, Judge.
Mhm.
Annex, may we have Mendola?
Do we have plea papers on that?
I didn't get any, Judge.
I didn't either. I think I asked for these yesterday, but
Yes, Judge.
Coming right up.
Mr. Olivas, did we get plea papers? You're muted if you're not
No,
frozen.
Judge, No, that was my fault. I looked at the calendar and I thought it was gonna be an in-person hearing. I had it 2 o'clock in the 168. I figured I'd just jump over to your court and take care of it before the hearing, but obviously I was wrong. It's not an in-person hearing, it's a Zoom. So I don't have the fee papers ready, Judge. I apologize.
Okay, so you want to reset it for the November 14th?
I'm
Or no,
sorry,
how
Judge.
are we looking- or how are we
you're-
looking on that?
I'm sorry, Judge. You're breaking up real bad.
November 14th?
Yeah,
There-
I'll get them to you, Judge. Yes, ma'am.
There, Judge.
I'm sorry, Myrna, what was that?
There's room, we can edit on the 14th.
Okay, let's go ahead and set it then.
Thank you, Judge. And again, I apologize for the inconvenience.
Thank you.
Thank you.
Next.
Pay when Mr. Oliva's judge.
Oh. Mhm.
He left. He left. Judge, on page 19.
Mhm.
And next, we have Nip, Samuel Nip.
Do I sit down?
Yes. He's in the downtown.
Oh, okay, thank you. Yeah.
So who's handling this one?
I am, Your Honor.
Oh, I know you are, Mr. Nunez, but who's handling it for the state?
Your Honor, this is a BPU case.
Okay, so we're not ready. We'll go to the next one.
Yes, Your Honor.
Are you handling Mr. Vandenberg?
No, it's a BPU case. It's a different prosecutor.
This is,
Okay, Judge.
Next.
Top of page 20, Judge. And next, we have Lara, Fernando Lara.
Is this Mr. Huffman or is it someone else?
I believe so, Judge. Yes, ma'am. Mr. Hoffman, are you there?
All right. I'm gonna go to the next one.
Yes, Judge. I have a minute. Ms. Payan, who's your client?
Hector Martinez.
And next, we have Martinez, Hector, middle of page 20, Judge.
Mhm. Is that Mr. Martinez?
Yes, ma'am.
Mr. Ortega, are you on this one?
Yes, Your Honor.
Okay, let's go.
Cause number 2021 0D02834, State of Texas versus Hector Martinez. Announcement of council, please.
Chantal Ortega for the state. The state is ready. Edith Payan on behalf of Mr. Martinez, and we are ready, Your Honor.
And Mr. Martinez is appearing remotely from the jail annex. We are scheduled for a bond hearing. Ms. Payan, you may proceed.
Thank you, Your Honor. I filed a motion to reduce bond on October 23rd of this year. In my motion, there's a bit of a timeline which is directly relevant. As of today's date, Mr. Martinez has been continuously incarcerated for 762 days. There were some competency issues. He had been sent to the Rio Grande State Center on the initial commitment, and then there was a 60-day extension. He's been back in the El Paso County Detention Facility as of October 13th. The bond is $2,500 and the family is unable to post that bond. The complaining witnesses in this indictment are his parents, Mr. Sergio Martinez Duran and Irma Sotelo Chavez. I don't know if they're attempting to log on. We had sent the Zoom number to the family. A sister was supposed to help. Provided non-prosecution statements to the state. When this incident happened, Mr. Martinez was having a psychotic episode. He was having some issues with his schizophrenia. There's even a mention of it in the report that he is schizophrenic. The family had called asking for help with Mr. Martinez because obviously he was not doing well. They did not want him arrested or prosecuted. I would like, Your Honor, for the court to grant a PR bond. We have a safety plan whereby we would link him to Emergency Health Network. Judge, since he came back from the state hospital, he is a priority and they do have to keep him on the same formulary. He is getting his medication. And candor to the court, he's taking medications in the morning and in the evenings. There's a dose in the mornings that for some reason he is not taking. I've not had an opportunity to talk to him about that. But I think we can work with him, Your Honor. He is taking the evening medication and he is stable. The parents want him back home. They live at 4737 El Campo in El Paso. And again, they do need him back. We need to get him linked to Social Security. But again, he would be a priority with Emergency Health Network as he's coming back from the state hospital. We can link him, get him on his meds, get him in whatever programs might be most beneficial to him. For now, it would be Takumi, but I would like to explore other programs like the assisted outpatient treatment program. At this time, I'm not sure if he'll qualify, but given his competency issues and the non-prosecution, I'd ask for a PR bond and hopefully I can work with the state to resolve this matter favorably. I don't know what other information the court would like from me at this time.
This is where my questions are going to start, are going to be with in terms of the I guess in a sense supervision of the medication upon release. How are we ensuring, like, does he already have an appointment with EHN? How are we going to ensure that he is?
Unfortunately, we did not get that appointment scheduled yet. I spoke with my social worker on that. That was miscommunication on my end, but they're assuring me that it wouldn't. So one, Your Honor, when he gets released, he would get released with 10 days of medication. And then
whatever dosage that he's getting morning and night.
Okay. Yes, ma'am. It should be. Judge, if I could have a minute, can I borrow you? Judge, I have a social worker here. We won't have her on screen because she's in a Halloween costume, but she's our chief social worker. They released them with 10 days at the dosage you're getting in the jail, correct?
Correct.
Yes, it would be, and the mother's unable to log on for some reason. They didn't want to show their support.
Okay,
And
I don't see anybody. I don't see anybody in the waiting room.
Okay.
Why isn't he taking those 2 doses at the jail?
It's 1 dose in the morning, Your Honor, and if we could ask him, Judge, unfortunately, I didn't get a chance to talk to him about it because I was reviewing everything this morning, but he's being prescribed olanzapine and Divalproex. The morning olanzapine is 10 milligrams, and in the evening, it's 20 milligrams. For some reason, there's been an issue with the morning olanzapine. If the court would like to question him about it, I have no objection. I do not know the answer.
Mr. Martinez, I'm hearing from your attorney, you're due to take medications twice a day. Why aren't you taking the morning one? What's going on?
I'm not sure.
Okay, so I'm not sure I'm quite there yet, Miss Bayan. I get it, but I'm not understanding why, if he's in custody, he's not on track, right? That should be the one place where the medication should be automatic in a sense. And so it makes me wonder, how is he going to be med compliant upon release if we don't have an appointment date? This is where I'm at. If I can get an explanation about full compliance with meds while he's in custody, and if you can get an appointment scheduled with EHN I don't have a problem looking at a PR bond under those circumstances with a date certain.
Your Honor, would it be, does the court have time to reset us for next week? That would give me time to go out to the annex to talk to him and see what's going on and get that appointment?
Maybe not. Hold
Okay.
the thought right there. Let me hear from Ms. Ortega.
Your Honor, we're not opposed to, this defendant being out on bond. However, I would point out that Sergio Martinez, who is the father, is listed as the victim on the case. And I believe Ms. Mayan said that that's where he would be going back to. So that's concerning to the state. Beyond that, we do believe this individual needs treatment, and the recommendation from the state is 3 deferred to resolve the case.
Ms. Ortega, have you all been in touch with the complainants in this case?
So we just got this one back, Your Honor. I have not been in touch with them, and we will endeavor to do that in the next few days.
Ms. Bayan, in terms of scheduling, I think you're both getting what last questions I have. In terms of actually scheduling a hearing, that may be difficult next week, but I would be happy to conference it with you and Ms. Ortega. So if these questions are answered, we can address the bond. I just don't think I can schedule you because we're in trial.
That's even better. I'll work with Mr. Ortega. I can get myself to the annex hopefully Friday morning, get that appointment. And if I can't follow up with Mr. Ortega, hopefully maybe sometime Friday afternoon, and nothing else, I'll email the court and the state with whatever answers I come up with.
Very good. Thank you very much, ladies. Again, I thought I mentioned this, but I don't see anybody in the waiting room. So if family was trying to get in, I don't see them there. Okay. Thank you very much.
Thank you.
Who's next?
Judge, going back to the downtown on page 19, Judge.
Does Mr. Martinez have future settings? Like, is he on a trial track? Let me double check. Yes, he is. Okay, good. Alrighty.
In cause number 2023-0D05903 and 2023-0D05895, State of Texas versus Samuel Alexander Nip. Announcement of council, please.
Preston Munson for the state stage ready, Your Honor.
And David Nunez on behalf of Mr. Nip, ready, Your Honor?
And Mr. Nip is appearing remotely from the downtown jail. We were scheduled for bond hearings in these cases. Mr. Nunez, you may proceed.
Thank you, Your Honor. Your Honor, Mr. Nip has been in jail approximately 10 days on a $200,000 bond. The bonds, respectively, are at $150,000, and the other case is at $50,000. I believe the one with one count is at $50,000. He is 18 years old. He is a United States citizen. As far as education is concerned, he is a high school graduate of Austin High School, class of 2023. Regarding his family, he is not married, does not have any kids, but he is the youngest of 7 siblings. As far as work is concerned, prior to his arrest, Mr. Nip worked at a parts manufacturer at a company by the name of Meyer Tool in Cincinnati, Ohio. As far as home, where he would live, if the court would allow his release, Mr. Nip would respectfully request that the court allow him to continue working in Ohio while the case is pending. And I do have an address available upon request. However, of course, if the court is not comfortable with that, Mr. Nip also has a place to stay here at Fort Bliss with his mom and his stepdad. Of course, and he is willing, of course, to abide by any of the court's instructions regarding attending any court hearings and such. I do have an address available at the Fort Bliss location upon request as well. Regarding criminal history, Judge, he has nothing aside from these 2 pending cases. And as far as the nature and circumstances of the offense, Judge, it revolves around 2 separate shootings. It's important to highlight, though, that as far as that evidence is concerned, Mr. Nip is not the alleged shooter in any one of these cases. And he has no relation to any of the CWs listed in either indictment. That said, the co-defendants in this case, they both have serious criminal histories and, to my knowledge, are active gang members. They all got to know each other because they all had common friends in common. And at the time of the first incident, I think as the evidence unfolds, Judge, we're going to come to find out that Mr. Nip, did not know about any of the firearms that the co-defendants were carrying and did not know or conspire to shoot anyone. And that goes for both incidents. And I think as the case develops, we're also going to come to find out that, the co-defendants did threaten Mr. Nip, to not say anything and continue keeping tabs on him up until the second incident. Again, well, aside from that, based on the reports, Mr. Nip did fully cooperate with police when asked about the incidents and was not arrested up until 10 days ago. And he spoke with police sometime back in August. And essentially what I'm trying to say, Judge, this is a case of an 18-year-old kid with no criminal history, essentially being intimidated by someone with people with firearms and making him actually, do favors for him. For someone with no criminal history that has, no violent past, I think we can keep an open mind that, it's hard to say no after knowing what they're capable of, as far as the co-defendants are concerned. Taking all this into account, Judge, Mr. Nip is currently unable to afford the bond where it's currently set at, and is respectfully asking the court to lower it. And we would hope that it would be around the $15,000 range. And additionally, I have presented the court and as well as the state with a character packet for its review. Included in this character packet, we have character letters from school counselors, pastors, church members, law enforcement personnel, among others. And I'm just hoping that these letters convey to the court and show the court that the type of person that Mr. Nip is, as well as convince the court that his bond should be lowered. And with that said, Judge, that's all I have, and thank you for your time.
All right, Mr. Munson.
Your Honor, we'd be opposed based on numerous reasons. One of them being, while these are two separate incidents and he's not the alleged shooter in either of them. The first one, it's with the same co-defendant in both times. There are other co-defendants in the first shooting. It also, the first shooting, the co-defendant used a shotgun. This is a weapon that's not going to be concealed, so he knew the shotgun was there. There's not something you can't see, that you can't really hide that one. And then the second shooting, he is the getaway driver for the shooter, and this is concerning for us. If it was just something that he didn't know he was getting involved in the first shooting, why was he hanging out with the same person in the second shooting? Tells me he's involved in this criminal enterprise that we believe they're all part of. Another issue is that he's apparently working in Ohio. I'm concerned with the contacts with our community, whether it's a danger for us or a danger for Cincinnati or in Ohio, regardless where he's living. I'm concerned for the citizens of wherever, here or there. But also, I'm concerned if he's going to come back if he's in Ohio when we need to have a hearing.
Mm-hmm. Anything else?
That's all, Your Honor.
Mr. Nunez, anything else?
Yes, Your Honor. With respect to him living in Ohio, he actually told the detective that he was in fear for his life as far as the co-defendants are concerned. And as far as the co-defendants are concerned, they're both involved in both cases. And as I mentioned before, they kept tabs on him after the first incident had happened. And, they have the same friends in common. So as far as that's concerned, he was being threatened and found himself, again, being intimidated by these groups of individuals, or not a group of individuals, by these two individuals who are active gang members. And essentially, as I said before, Judge, it's an 18-year-old kid, and knowing what these two people are capable of, it's hard to say no to someone with a gun. So that being said, that's all I have, Judge.
Right. Thank you very much. Your request is respectfully denied based on the nature and circumstances of the offenses, the safety of the community, the lack of ties to the community. Those are denied. Thank you very much, Mr. Nunez. Who's next?
Thank you.
There you go.
Bottom of page 22, Judge. Next, may we have Ulloa, Alexander Ulloa.
Your Honor, can downtown be excused?
Do we have anyone else in downtown?
No, Your Honor.
Thank you.
Thank you.
All right, go ahead.
In cause number 2023-0D00178, State of Texas versus Alexander Ruben Ulloa. Announcement of council, please.
And Teller take it for the state. The state is ready.
Jaime Olivas for Alejandro Ulloa. Your Honor, we are ready.
And Mr. Ulloa is appearing remotely from the jail annex. We're scheduled for a bond hearing. Mr. Olivas, you may proceed.
Thank you, Judge. Your Honor, Alex Ulloa is a 35-year-old United States citizen whose permanent address is 429 Tanya here in El Paso. He was born and raised in El Paso. He graduated from Montwood High School in 2004. He previously had a job as a machine operator for 17 years. He is divorced from his wife, Martha Arredondo. However, he has two children, an 8-year-old and a 10-year-old, for which he is responsible and pays child support. He also has a sister that lives here in El Paso who is willing to sign on the bond if the court sees necessary. The reason Mr. Ulloa is not working, Your Honor, is that in January of 22, he had a massive hemorrhagic stroke wherein he suffered severe brain damage. Ultimately, he was disabled by the Social Security Service. He currently is on 100% disability. However, as a result of the stroke, Your Honor, he now suffers from seizures and gets them regularly. At the jail, he's been incarcerated since September 29th, and the jail is not providing the proper medication. He's getting Lectrum for his bipolar disorder and is also on Keppra for his seizures. He needs to get back on these as soon as possible, Your Honor. I have spoken to the complaining witness in this case, Ruby Ulloa. Her phone number is 469-439-7767. She has assured me that she does not want to pursue the charges against him, that she has indicated that she will provide a non-prosecution. However, we have not gotten that as of today's date. He is 35 years old, Your Honor, and he's in need of medication and medical attention. He currently is on a $100,000 bond, Your Honor, that was revoked for the assault on Miss Ruby Ulloa, as well as a $3,000 bond. I'm sorry, as well as a $6,000 bond for theft. And the issue, basically, it's his own house that he went in to retrieve some personal items, but we'll get down to that. Respectfully, Your Honor, he is, like I said, 100% disabled and paying child support. He cannot make a $100,000 bond. We're asking if this court would consider and putting $1,000 cash corporate surety with the remaining, say, $10,000 in PR bond, so that we can get him his proper medication and get him out of jail in order to receive treatment.
And I
Thank
am
you, Judge.
seeing, thank you. The clerk is telling me here, we have a bunch of cases for him, right? We have.
Well, there's 3 P files, Judge, that are pending.
They're not P files anymore.
They're indicted. I have 3 more indicted felonies.
Okay, I have not gotten.
It was just a few days ago. It looks like, well, the indictment came out on the 18th. I don't know
And
that he's booked on any of these.
Okay, Judge, those are $10,000 bonds each, and I was going to take it. However, if this court can entertain them, we would ask that you set bonds on PR, the 3 remaining. There are 2 violations of protective order and 1 telephone harassment. It was the same complaining witness, Judge. My understanding is they were talking about getting back together and things fell apart. Mr. Ulloa understands clearly that he is not to contact this lady. He is not to in any way harass her or mess with her. That's why I had been in contact with her, and she seems like a wonderful young lady that is willing to sign a non-pros, Judge.
So for the record, those that new cases or newly indicted cases are 2023 0D06764, 6765, and 6766. All righty, and he's at 100,000 here. I think I looked up on the PR Revo. There was something, I actually was reading a PR Revo, and it mentioned something about him going to Dallas, but that was on the misdemeanor. So let me hear from you, Ms. Ortega.
Yes, Your Honor. So by way of criminal history, I think I'm echoing on Mr. Olivas' side, but by way of criminal history, it's a 2006 harassment. He's on for deferred 45 days, ended up in a conviction. 2007, burglary of a building, 60 days conviction. 2007, AFV, 5 days conviction. 2016, a DWI, lesser, 60 days conviction. And really, I understand that Mr. Olivas is saying that, this woman is saying she will sign a non-pros, but our office has spoken to her earlier this year. That was after the offense that we're alleging occurred on February 11th, 2023, which is the stalking case. And she told us she was very concerned about the defendant getting out. Mr. Olivas is saying that this defendant understands clearly he can't talk to her. But Your Honor, we would propose to you that he doesn't understand because she was the victim in the December 10th, 2022 AFB, the evading arrest, and then still violated the protective order on December 11th, 2022, and then continued to stalk this woman on February 11th, 2023, and then broke that protective order on April 10th, 2023. This man is a danger to the community and to Miss Ulloa, and we respectfully ask that the bonds be kept as they currently are.
Is there an aggravated assault deadly weapon out of Dallas?
I don't have the updated rep pulled up, Your Honor. One second.
On the PSR that I am reviewing, it is referencing, I was thinking this was maybe a hit on our case, but it is not. Ours is an assault family violence. This one says Agency Sheriff's Office Dallas, NCIC wanted aggravated assault with a deadly weapon, case F233-4295J, date of warrant 10/23/23.
That would be the more recent one, Your Honor, and I don't have that pulled up on the wrap.
All right.
Judge, I do not represent him on the Dallas case. I do not believe it involved any weapons, but I don't have accurate information.
No, I don't have, Mr. Olivas, your request is denied for the reasons stated by Ms. Ortega. I don't think his track history is one that the court can be comfortable allowing him out on a bond. He has a bond of 100,000 here. It is 100,000 because he was not in compliance here. So for the safety of the community and a prior non-compliance, that request is denied. We do have now 3 new cases. So Ms. Hernandez, we need to get all of those on track. Mr. Olivas, we're set for trial in February 2024. So I'm happy to put the new ones with this one, but it is a tight timetable. So, but your client's in custody. So I'm inclined to do that. And if you find come February 2024, you need more time, I'll see that these are 3 newer cases that could have had a little bit more of a timetable.
Very well. Thank you for your courtesy, Judge. Everybody have a good day.
You too. Yeah. Thank you, Mr. Law. Who is next?
Judge, on page 21 with Mr. Serang. His client is in quarantine.
His dog is not. All right, Mr. Owings, what do you want to do on that, Mr. Serang? Oh.
His dog almost got my dogs to go out it.
I'm sorry, Judge. Like somebody at the door, so they're
So
barking.
we don't have your client. Do you want to come back in 2 weeks?
He's in custody, Judge.
He's in quarantine.
Oh, okay.
Want to try in 2 weeks? I can schedule you for the 14th.
Sure, let's do it.
Okay, reset for the 14th. Thank you very much.
Thank you, Judge.
And if you want to give me a call, we can discuss.
Okay,
Since he picked up those new ones, okay?
yeah, okay, thank you. I will, bye-bye.
Thank you.
Bye-bye. Who's next?
Bottom of page 18, Judge. Annex, may we have Garcia, Anthony Garcia.
Yes, sir, just coming up. Right there. Ready, Your
Right.
In cause number 2023-0D03204, State of Texas versus Anthony Isaac Garcia. Announcement of council, please.
David Vandenberg on behalf of the state is ready.
Chris Anchon on behalf of Mr. Garcia, we are ready.
Mr. Garcia, I did receive documentation from your attorney indicating you intend to plead guilty in this case. Is that your understanding of what we're doing here?
Yes, ma'am.
I also received a waiver of doing this plea in person. In other words, agreeing to do it here on Zoom. Is that what your agreement was?
Yes, ma'am.
Okay, so let's get started with your plea. Would you raise your right hand, please? Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down. Please state your name and date of birth for the record.
Anthony Isaac Garcia, 11/08/2004.
Mr. Garcia, as I mentioned, I did receive paperwork from your attorney. The first document is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Garcia, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, ma'am.
Did you understand everything contained within that document?
Yes, ma'am.
Mr. Anchondo, have you had more than 10 days to prepare a defense in this case?
We have, Your Honor.
And did you explain the plea papers to your client?
I did.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
I do, Your Honor.
Mr. Garcia, are you satisfied with your attorney's representation of you?
Yes, ma'am.
Mr. Anchondo, any reason to believe your client is not presently competent to enter his plea?
None whatsoever, Your Honor.
Mr. Garcia, have you ever been found mentally incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea. Mr. Garcia, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
Here in El Paso.
Paso, Texas?
Yes, ma'am.
Okay, in this case, you were charged by indictment with the 3rd-degree felony offense of possession of a controlled substance in penalty group 1 or 1B in an amount between 1 and 4 grams. To that charge, sir, what is your plea? Guilty or not guilty?
Guilty.
Are you making your plea freely and voluntarily?
Yes, ma'am.
I will find you are making your plea freely and voluntarily. Mr. Vandenberg, would you summarize the evidence, please?
Your Honor, had this matter gone to trial, the state of Texas would have been able to prove beyond a reasonable doubt that on or about the 11th day of October 2022 and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Anthony Isaac Garcia, hereinafter referred to as defendant, did then and there intentionally or knowingly possess a controlled substance, namely methamphetamine, having an aggregate weight, including adulterants or dilutants, in an amount of 1 gram or more, but less than 4 grams. At this point, Your Honor, the state would request that Exhibit 1, the plea agreement, and Exhibit 2, the 3914 disclosure form be admitted.
No objections, Your Honor.
States 1 and 2 are admitted. What is the plea agreement?
The state recommends that Mr. Garcia be sentenced to 5 years community supervision under the deferred adjudication provisions. He be assessed a fine in the amount of $2,000 with $2,000 probated, payable immediately or in equal monthly installments throughout the term of community supervision. Additionally, the state recommends imposition of all the standard terms and conditions of community supervision, as well as that defendant perform 200 hours of community service prorated monthly as a condition of community supervision. that he be on the substance abuse caseload to include TAP, be subject to UAs and BAs and a curfew, Your Honor.
Mr. Anchondo, is that your understanding of the plea agreement?
Yes, it is, Your Honor.
Mr. Garcia, is that your understanding as well?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled the Trial Court Certification of Your Right to Appeal. It's a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Garcia, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
It was signed by your attorney and signed by the court as well. Finally, the motion for deferred adjudication. Mr. Garcia, do you recall reviewing with your attorney the motion for deferred adjudication before you signed it?
Yes, ma'am.
Mr. Anchondo, have you advised your client of the detriments, the benefits and detriments of deferred adjudication?
Yes, Your Honor. He's aware of the benefits and the detriments if he were to violate his probation.
Mr. Garcia, do you understand if you violate a condition of deferred adjudication, the court can proceed to sentence you up to the full range of punishment, which is anywhere between 2 and 10 years in prison? Do you understand that?
Yes, ma'am.
And are you still asking the court to grant you deferred adjudication?
Yes, ma'am.
I will find there is sufficient evidence in this case to substantiate a finding of guilt. However, I will not enter a finding of guilt at this time. Instead, I will defer further proceedings and place you on deferred adjudication probation for a period of 5 years pursuant to the plea agreement. There will be a $2,000 fine, the entirety of which is probated, which means you will not owe the fine as long as you're compliant with your probation. If you're not compliant, you owe the entire fine. 200 hours of community service, screen for TAP, subject to urine breath analysis, curfew from 9 p.m. to 6 a.m. unless you are working or going to school. Is there anything else, Mr. Vandenberg?
No, Your Honor.
Mr. Anchondo?
Nothing further, Your Honor.
Mr. Garcia, I wish you well. Do well on your terms and conditions of probation. Please do not give me any cause to bring you back here. Follow everything probation tells you to do. And if you have any questions, work with probation and come to the court if you need assistance, okay?
Yes, ma'am.
Thank you very much. Good luck to you, sir.
Thank you.
Thank you, Judge. May I be excused?
You may have a good day. I think we need to take a break because we've been going since 2 o'clock.